31A, 31B, 31C. That's it. So I hope you are ready for this particular session. And let me just switch on the chat window so that even will start to open your chat. ప్రతిసారి ఏదో ఒక టెక్నికల్ ప్రాబ్లం. Just allow me a minute. I'm just switching on the chat window. అది మొత్తం బయటికి వచ్చేసి బయటికి ఫస్ట్ మళ్ళీ ఒకసారి ఓపెన్ చేయండి. Yeah, so let me just go with this particular thing. So going through my studio, I think everything is perfectly audible and visible to everyone. Yeah, very good, very good. Yeah, hi Charan, welcome to the session. How are you? So guys, today this is our 13th lesson, right? 13th lesson on the complete course on Constitution of India. Hi Haindavi, hello Charan, welcome to the class. So before getting into the class, I just want to inform you that we are launching we have already launched a batch which is known as Master Law, which is a 6-month batch for the CLAT examination, which is actually a 6-month batch for your other state law entrance exams like TS Law CT, AP Law CT, Maharashtra CET, and BLAT, and also PUCET Law. So if you're somebody who's preparing for any of these examinations, you can directly enroll in this particular batch by using a very important code of mine, which is Thrinath 10. You can use this code to get maximum discount on all plus and iconic subscriptions on the Unacademy Learners application. Hi Vaishnavi, welcome to the class. How are you? Then we are also coming up with a price hike. We are going to increase the prices of our CLAT Plus and Iconic subscription, not only for CLAT but also for other law entrances. We are going to increase the price very soon. So please make sure that you are enrolling into our Plus and Iconic subscriptions before we are increasing the price. So if you have joined this session, please make sure that you're hitting the like button. And these are the price charts. You can use my code Thrinath10 THRINATH10 to get maximum discount on all the subscriptions on the Unacademy app, not only in CLAT but also in judiciary, UPSC, UPPSC, SSC, SSC, non-technical, NDA, and lot of other categories which are there on the Unacademy Learners application. So now with this note, let us just proceed with our today's class and welcome to the 13th lesson, where we are going to discuss articles 31, 31A, 31B, and also 31C, which are generally considered to be exceptions to fundamental rights. Very good. Let me just go. In the video. Yeah. Good evening, Kavya. Welcome to the class. How are you? So guys, we are done with article 30 in our last class. So आज की इस बहुत इंपॉर्टेंट सा सेशन में हम डिस्कस करने वाले हैं नेक्स्ट इंपॉर्टेंट आर्टिकल, which is article 31. Now, article 31 is right to property. As I told you in the previous class, right to property was one of the 7 fundamental rights. So when at the commencement of Indian Constitution, there were around 7 fundamental rights. There were 7 fundamental rights, and now we have only 6 fundamental rights. Just give me a second. I'm adjusting the chat window in this particular form. Yeah. So right to property, it was earlier a fundamental right, and it provided that no person shall be deprived of his right to property except by an authority of law. But after a lot of cases which were filed in various courts, like if you see, we have seen Golaknath case and also Keshwananda Bharati case and all of these cases. After all these cases were filed, the right to property was removed as a fundamental right. So now, when after the commencement of Indian Constitution, a lot of people were having a lot of land holdings, and state actually want to have a ceiling limit. So there should be a limit on the holdings of land. So that is why certain property was acquired from some individuals, and these individuals went to the courts and they filed a lot of cases, which created a lot of tension between the government and also the judiciary. So now, however, being one of the most controversial rights, the 44th constitutional amendment has abolished the right to property as a fundamental right and made it a legal right or a constitutional right under article 300A in part 12 of the Indian Constitution. A very important question for all your upcoming law examinations. They might ask you a question. Right to property was removed by which constitutional amendment? So the answer is 44th Amendment Act of 1978, and it is placed as a constitutional right under article 300A which is in part 12. So now, is this a constitutional right? Yes, this is a constitutional right, and it is also a legal right. So what do I mean by legal right? Which means in order to enforce right to property, a law has to be enacted by the parliament. Okay. Now, Article 31 led to a number of constitutional amendments, that is first, 4th, 7th, 25th, 39th, 40th, and also 42nd. So now if you see the first set of landmark judgments which were there in India, like Shankari Prasad, Sajjan Singh, Golaknath, Keshwananda Bharati, all of these cases are because of this right to property. So that is why a lot of amendments were made by the Union Parliament. And the first amendment of 1951 has inserted Articles 31A and 31B to the Constitution, and 31C was added by the 25th Constitutional Amendment Act of 1971. So 31, you need not know much about it because it is no more a right. Now we are going to discuss about Articles 31A, 31B, and also 31C, which are currently a part of the Indian Constitution. So हम देखते हैं what is 31A. Now 31A saves 5 categories of rights from being challenged and invalidated on grounds of contravention of the fundamental rights conferred by Articles 14 and 19. Now, 31 under 31A, there are 5 categories of laws. At this point in time, it is not very important to remember, but I'm going to show you what are those 5 categories, and you cannot challenge these 5 categories of laws which are there under 31A if they are violating Articles 14 and 19. As you know, if fundamental rights are violated, you can go and directly challenge it in the Supreme Court. But if these 5 categories of law are violating Articles 14 and 19, you cannot challenge them in any court. But this is not the position right now. We are going to talk about the updated position later in the next slide. But before that, let me just show you what are these 5 categories. It is not very important for your examination, but let me just show it for all of you. I hope you all can look at my screen. 31A, saving of laws providing for acquisition of estates, that is acquisition of state and the acquisition by the state of any estate or of any rights therein, or the extinguishment of modification. And there are 5 categories of rights which are not very important for your upcoming law examination, for law entrance exams. You can just remember that there are 5 categories which can be saved even if they are violating the fundamental rights under Article 14 and 19. Now, is this the same position now? Is this the same position now? If the rights are violating, can we not challenge it in any court of law? The answer is no. Why the answer is no? Because there is a very important case which I told you, that is IR Coelho versus State of Madras. In this case, it said that any matter, no matter in the Indian Constitution is not subjected to judicial review, which means every matter, every subject in the Indian Constitution is subjected to judicial review if it violates the basic structure. Okay, we are going to talk about basic structure very soon. Before that, let me just talk to you about 31B. 31A is talking about 5 categories. It saves five categories of fundamental rights. You cannot challenge these 5 categories of laws in any court if they are violating Article 14 and 19. 31B protects the acts and regulations which are included in the 9th schedule from being challenged and invalidated on the ground of contravention on any of the fundamental rights. If any fundamental right, if there is violation of any of the fundamental rights because of the subjects which are there in 9th schedule, they cannot be challenged in any court on any ground. Okay, I hope this is clear. And the scope of 31B is wider than 31A because 31B immunizes or it protects all the laws which are included in 9th schedule, whereas 31A protects only 5 categories of rights. Okay, but now, is it the case that if any of your fundamental rights are violated or if the basic structure is violated, you cannot challenge in any court of law? The answer is no. Supreme Court told in its very important judgment, which is IR Coelho versus State of Madras, a judgment in 2007, all laws which are there in the 9th schedule after Keshwananda Bharati case, that is after 24th April 1973, they can be challenged in the constitutional courts on ground of violation of basic structure or on ground of violation of fundamental rights. I hope this is clear for everyone. 31A and 31B. Please give me very quick response in the chat window. I don't know how many of you are paying very close attention to this particular session. This is a very important rights because these are exceptions to fundamental rights. Okay. Let me proceed with the next article or the last article of this day, 31C. 31C contains provisions. You might not understand 31C because there are certain provisions in 31C which are dealing with DPSPs. Don't worry if you don't understand what is Article 39B and also Article 39C. We are going to discuss it when we are discussing DPSPs, which are in Part 4 of the Indian Constitution. Now, under 31C, we have two important provisions. First one is that no law that seeks to implement the socialist directive principles which are specified in Article 39 Clause B and also 39 Clause C shall be declared void on the grounds of contravention of fundamental rights conferred by Article 14 or Article 19. To put it in simple words, if to enforce any of the DPSPs which are there under 39B and 39C, we are going to talk about it when we are going to discuss DPSP. To enforce these rights, if fundamental rights of 14 and 19 are violated, you cannot challenge them in any court. Okay. Next, moreover, no law containing a declaration that it is for giving effect to such policy shall be questioned in any court on the ground that it does not give effect to such a policy. Now, if there is any law, which is giving effect to 39B and 39C, you cannot question it on any ground on any court. That is very clear. And then Articles 31A, 31B and 31C, they have been retained, which means they are still there in the Indian Constitution and they act as exceptions to fundamental rights. Okay, Charan, you want me to repeat which one? You want me to repeat which article? Now let me just sum up and revise. No, it is not that 39A. It is not that, right, Vaishnavi. That is altogether a different thing. Here we are talking about 39B and 39C, which are a different thing. Okay, we are going to talk about that in DPSP. So now please remember, just very quick, very 31B. Okay, I am coming there. 31A saves 5 categories of rights. 5 categories of rights. If these 5 categories of laws are violating Articles 14 and 19, you cannot challenge them in any court on any ground. This is 31A. Now, Charan did not understand what is 31B. See, Charan, 31B is very simple. All the subjects, okay, all the subjects which are there in 9th schedule, okay, 9th schedule. There are 12 schedules in the Indian Constitution. 9th schedule was added by first constitutional amendment. All the subjects which are there in 9th schedule, they cannot be questioned in any court on any ground that they are violating any of the fundamental rights. If any subject in 9th schedule is violating your fundamental rights, then you cannot question them in any court of law. Okay, but after the judgment of Supreme Court in IR Coelho versus State of Madras, you can question or you can file a case against any subject which is there in 9th schedule, which is included in the 9th schedule after 24th of April 1973, because on 24th April 1973, Supreme Court delivered its very famous and landmark judgment, which is known as Keshwananda Bharati versus State of Kerala. In Keshwananda Bharati versus State of Kerala, the doctrine of basic structure was propounded. Now, what is this basic structure doctrine? If Parliament is enacting any law and if that particular law is violating basic structure, then it can be struck down by the courts as null and void. Okay, so now in IR Coelho versus State of Madras, Supreme Court said that even 31B or any subject which is there in 9th schedule, they can be questioned if those subjects are included after 24th of April 1973. Is this clear for you, Charan? I hope this is clear. Chalo. So these are 3 important articles which are there, under 31A, 31C. Let me go to 31C. 31C protects 2 important rights, that is 39B and also 39C. If to give effect to 39B and 39C, if 14 and 19 are violated, then you cannot question them on any court on any ground. Okay, so this is what I wanted to convey in today's class or in this class, and we are going to have our next class which is at 8 p.m. Okay, next class is going to start at 8 p.m. At 8 p.m. we are going to discuss right to constitutional remedies, which is the heart and soul of the Indian Constitution. It is a very important class and I want all of you to attend this particular session without fail at 8 p.m. So make sure that you are attending this particular session at 8 p.m. And at the end, if anybody wants to take any of the Unacademy subscriptions, you can definitely use my code and enroll in this particular thing before the price is getting high. We're going to increase the prices very drastically. So please make sure you're subscribing before it comes. And see you all at 8 p.m. in today's class. Today's class at 8 p.m. we're going to discuss right to constitutional remedies. Bye bye.